Hello, my name is Libby McVeigh and I'm the Head of Law Reform at Fair Trials International, a non-governmental organisation that works for the improved protection of the right to a fair trial according to international standards. We do this in three main ways. Firstly, by helping people to understand and defend their fair trial rights. Secondly, by addressing the root causes of injustice through our law reform work. And thirdly, through targeted training and network activities to equip lawyers to defend their clients' fair trial rights. Working with our Legal Experts Advisory Panel, or LEAP, a network of over 130 criminal justice experts from across all 28 EU member states, we've contributed to the negotiations surrounding the adoption of the first three EU defence rights directives on the right to interpretation and translation, the right to information and the right to access a lawyer. And we've been working very hard for the past year or so to inform the development of three further defence rights measures on procedural safeguards for children in criminal proceedings, the presumption of innocence and the right to attend trial, and the right to legal aid. These measures were proposed by the Commission in November 2013 and are the main topic of this presentation. During this presentation, I'll start by setting the scene, explaining the policy context within which these latest three proposals were published, before moving on to provide an overview of each of the proposals' content and some initial thoughts on how we think that they could be strengthened, along with an overview of the current state of play of the negotiations. I'll also conclude with some thoughts as to what lessons can be learned by policymakers and practitioners from the experience to date of the implementation of the first three defence rights directives. And we very much hope these lessons will inform the process of negotiation and adoption of these directives and, of course, their eventual implementation. So I'll start with some scene setting. As judicial, police and prosecutorial cooperation increased following the Amsterdam Treaty in 1999 and based on the single market concept of mutual recognition, the idea of a judicial decision made in one EU member state being automatically respected and applied by judicial authorities in other member states quickly found favour, particularly in the aftermath of the 9/11 terrorist attacks. It took a further 10 years, however, for the EU to recognise that without a corresponding strengthening of defence rights protection in many, if not all, member states, there was simply no sound basis for the mutual trust upon which mutual recognition depends. We need look no further than the record of member states before the European Court of Human Rights to see that compliance with Articles 5 and 6 of the European Convention in criminal cases has often fallen short, with member states found to be in violation of those rights in 640 criminal cases between 2009 and 2013. And so, in 2007, the Lisbon Treaty recognised the need for fair trial rights to be addressed as a prerequisite for the success of mutual recognition in the area of criminal justice, with Article 82(2 enabling laws establishing minimal rules for the rights of individuals in criminal proceedings to be made where necessary to facilitate cooperation in cross-border cases. This development set the stage for the procedural rights roadmap adopted in 2009 under the Swedish presidency, which set out a step-by-step approach to establishing fair trial rights standards which would become binding upon member states. This step-by-step approach was far more palatable to member states than a previously proposed comprehensive defence rights measure. As I've already mentioned, the roadmap has to date produced three robust directives on fair trial rights, two of which have already passed their transposition deadlines and should therefore now be implemented by all member states. Once the rather lengthy and challenging negotiations of the third of these directives on access to a lawyer were concluded, the Commission decided to forge ahead with its journey along the defence rights road by publishing three further proposed directives. It's worth noting at this stage that these proposals were accompanied by two Commission recommendations. One on safeguards for those vulnerable suspects not covered by the proposed directive on procedural safeguards for children, who, despite being included in the roadmap list, the Commission decided it was just too difficult to define them for the purposes of granting rights entitlements within criminal proceedings in a binding legislative measure. The other recommendation was on certain aspects of legal aid, and indeed certain very important aspects of legal aid, which the Commission thought might weaken the prospects of reaching agreement on the proposed directive on legal aid if included in that proposal. I'll not say much more on those recommendations during this session, but it's certainly worth knowing that they exist, albeit currently in wholly unenforceable and widely ignored form. So let's then turn and look more closely at the content of these latest three proposals, and I'll take the proposal on safeguards for children first. Looking first at why this measure was needed, in its impact assessment which accompanied the proposal, the Commission set out many of the concerns which have been raised through our own casework and in discussion with our network members about the varying standards of protection for child suspects in criminal proceedings across Member States. This variation is perhaps most comprehensively articulated in a comparative report published by the European Commission in June 2014, which flagged significant differences in approach, for example, in relation to contact with parents or other appropriate adults during proceedings, the provision of legal representation, maximum periods of pre-trial detention for children, the protection measures available to children during interviews, and the balancing of the right to privacy of children in criminal proceedings against the protection of freedom of information. And we've been made aware of numerous cases where inadequate safeguards for children have resulted in grave injustices. Cases involving the aggressive questioning of young teenagers by police without any adult or lawyer present, cases involving the lengthy pre-trial detention of young children alongside adults, and those which involve the inadequate legal representation by non-specialist lawyers not used to dealing with child suspects, which have resulted in miscarriages of justice. Criminal proceedings are a daunting prospect for all suspects, but children are especially likely to be overwhelmed and damaged by the experience. They may be unable to follow or fully participate in the proceedings, which can seriously undermine their ability to receive a fair trial. They may also be subject to inappropriate treatment during the proceedings, which of course breaches their rights to be free from harm and can of course have a long-term impact on a child's well-being. The European Court of Human Rights jurisprudence has centred on the concept of ensuring that children are able to effectively participate in their criminal proceedings, with special adaptations inevitably being required to facilitate such participation. As we turn then to the content of the proposed directive, which applies to all children defined as under 18, throughout the criminal proceedings, excluding proceedings relating to some minor offences, and irrespective of whether they turn 18 during the course of the proceedings, it's clear that the obligations which the proposal seeks to impose on Member States primarily relate to these necessary adaptations, all of which need to be tailored, of course, to the specific needs of the particular child in question. Central then to this approach are the individual assessment and the medical examination, which are required under Articles 7 and 8 of the proposed directive, which require the authorities to assess a wide range of aspects of the child, including their protection, education, training, and social integration needs, their personality, maturity, and economic and social background, and also their mental and physical condition, with a view to assessing their capacity to face questioning and other investigative measures. Article 13 then confirms that children should be treated in a manner appropriate to their needs, presumably as established through these assessments. The directive also proposes certain adaptations which will always be necessary for child suspects, irrespective of their individual needs, including the involvement of a holder of parental responsibility or another appropriate adult, the mandatory access to a lawyer throughout the proceedings which cannot be waived, and which is fully supported by legal aid provision, the use of audio-visual recording of police interviews, protections of the privacy of the child, including through holding hearings in the absence of the public, and prohibitions on dissemination of information which could lead to the identification of the child. And finally, we have provision relating to the specialist training of judicial and law enforcement authorities, as well as prison staff who deal with children. Reference is also made, notably, to the need for lawyers to receive specialist training, which is very welcome, not least because the 3 adopted directives that we have on the table so far make no reference to the training of lawyers, which we consider to be a crucial aspect of the effective implementation of these defence rights laws. I'll come on to explain a bit more about that later on. It is worth noting that the proposed directive on safeguards for children does feature derogations from certain rights where upholding them would be disproportionate or indeed contrary to the best interests of the child. So how then could this proposed directive be improved and the rights within it strengthened? We published our position paper on the proposal in September 2014, and it's available via the Fair Trial website. We're generally confident that the proposal covers the right types of protections, but we think that these could be strengthened in certain ways. For example, we'd like to see the scope of the directive apply to all cases, including those relating to minor offences, given the impact which the outcome of all such proceedings can have on the future life of a child. We'd also like to see a clearer statement of the need for all aspects of the proceedings to be tailored to the specific needs of the child, as informed by the individual assessment and medical examination, including, for example, the way in which information on rights and charges is provided to the child, which may need to be changed according to the levels of comprehension which that particular child has. We'd like to see more detail on the individual assessment, particularly on who is responsible for carrying it out, its scope, and how specifically the results it produces should be used. We're keen to see an expansion of the role of the holder of parental responsibility or the appropriate adult, so as to ensure that where in the best interests of the child, they are present from the earliest possible moment following arrest and prior to questioning. Further detail is also required on who decides whether to involve the parent or some other adult, and on what basis that decision is made. The obligation relating to audiovisual recording we consider to be an absolutely crucial one, and we'd like to see it apply in all cases with no regard being given to proportionality. We'd like to see the confidentiality obligations extended so that they apply after a child turns 18, so as to ensure that an individual's future is in no way tainted by what they have done or procedures they've been involved with as a child. And finally, we consider the inclusion of a remedies provision to be essential to ensure that children are able to enforce their rights when not automatically provided. So what prospects are there of us seeing these improvements to the proposal prior to adoption? Well, these will be determined obviously through the negotiations between the EU institutions, which we expect to take place later this year. But based on the Council's general approach, which was published in May 2014, the Member States seem determined to weaken the protections set out in the proposal, with a few concerning areas standing out. Firstly, there's an attempt to restrict the access of the child suspect to a lawyer in a broader set of circumstances than are permitted even in the access to a lawyer directive, including simply where the authorities deem it would be disproportionate to grant such access. Clearly, this would lead to a situation in which children have even less protection than adults in this regard, which defeats the purpose of this proposal. We're also concerned by the suggestion that the provision of legal aid to children should be left entirely to the discretion of member states and their national systems, without any inclusion of an obligation to ensure that the right to mandatory access is made truly effective for all child suspects. We're concerned by the amendments made by the Council to the individual assessment provision, which suggests that it should only be carried out in time to inform sentencing, which misses the prime purpose of the individual assessment, which is to inform the tailoring of the proceedings that lead to a final decision. There's the suggestion by the Council that some children may request a medical examination solely as a delaying tactic, and that in such circumstances the right to examination should be refused. This is very concerning, and we'd like to see that removed. The Council has also proposed a weakening of the provision relating to audiovisual recording, this vital protection of the rights of children, allowing for a far broader set of derogations, including where a child is not deprived of liberty, which in our view demonstrates a failure to recognise that children are particularly vulnerable during the questioning process, irrespective of whether they have been deprived of their liberty or not. We're concerned by the weakening of the privacy protections that the Council has proposed. It's suggested that in circumstances the authorities should be permitted to disseminate public information about the child suspect, which clearly in the majority of cases would not be in the best interests of the child. The Civil Liberties Committee of the European Parliament, under the rapporteurship of Caterina Canici from the S&D Group, an Italian prosecutor with experience in the juvenile courts, has yet to finalise its position, but based on the draft report which it published at the end of 2014, and true to form, it seems to be adopting a far more rights-friendly approach, which will certainly make for an interesting negotiation process. I'll now turn then to the proposed directive on provisional legal aid. We need look no further than the list of directives which have already been adopted to see why minimum EU standards on legal aid are urgently needed. The roadmap envisaged that a single measure covering both the right to access a lawyer and the right to legal aid would be adopted. But for reasons of political pragmatism, the decision was taken to separate these two topics so as to avoid negotiations on the right of access to a lawyer, which had been made more urgent by the European Court of Human Rights Saldou's judgment, to avoid these negotiations being tainted by obviously the economic arguments which would inevitably accompany any negotiation of a measure on legal aid. Based on the results of an EU-wide defence practitioner survey, which we conducted in 2012, and also regular roundtable discussions with members of our networks, it's clear that while there are legal aid systems operational in all 28 EU member states, there remain significant concerns raised by practitioners relating to the availability and nature of provisional legal aid systems, the management of legal aid systems, which does not always guarantee independence, the practice of reclaiming legal aid costs from suspects who are subsequently found to be ineligible for legal aid and or who are subsequently found to be guilty, which practitioners tell us often leads to waivers made solely out of the concern regarding the potential future cost liability and not out of the desire not to have legal representation. And finally, there are wide-ranging concerns surrounding the low remuneration of legal aid lawyers, which inevitably impacts on the quality of representation. So despite a certain amount of regional coherence provided by the European Convention of Human Rights, there remains a lot of variation and significant concerns about low standards of legal aid. Long anticipated as the answer to these challenges within the EU, the proposed directive on provisional legal aid is disappointingly narrow in scope. It covers, as I've said, what it calls provisional legal aid, defined as legal aid to a person deprived of liberty until the decision of legal aid has been taken. And it also covers, in the cases of European arrest warrant proceedings, it covers both provisional legal aid and legal aid defined more broadly to include funding and assistance needed to ensure the effective exercise of the right of access to a lawyer in European arrest warrant proceedings. This distinction between the provisional legal aid which the directive secures in ordinary criminal proceedings and the provision of both provisional legal aid and legal aid for European arrest warrant proceedings serves as an important reminder of the raison d'etre of these measures, i.e. to strengthen the operation of mutual recognition above all else. In non-arrest warrant cases, the proposal requires that access to provisional legal aid should be granted without undue delay, following deprivation of liberty and before any questioning, and should continue until the final decision on legal aid has been taken and indeed takes effect. While there's no mention of any eligibility assessment for this provisional legal aid, the proposal states that member states are entitled to recover the costs of providing that provisional legal aid from those suspects who subsequently do not meet the eligibility criteria for legal aid under national law. In EAW cases, executing states are required to ensure that requested persons have the right to legal aid from arrest until either surrender or the date of decision that not to surrender has become final, reflecting the right to access legal representation in both the executing and issuing state granted under the Access to a Lawyer Directive. The proposed directive on legal aid also requires that issuing states grant legal aid as necessary to obtain legal assistance in that state for the lawyer in the executing state. The proposed directive does suggest that the right to legal aid in arrest warrant cases may be subject to a means assessment in accordance with the eligibility criteria applied in each member state. And that is the sum total of the proposed directive's content. In terms of how it could be improved, well, while the proposed directive clearly targets one of the key issues of concern raised by members of our LEAP network, i.e. the ability of suspects to access legal advice in those critical first moments following arrest and during police station procedures, the scope of the proposed measure falls a long way short of giving effective access to the full scope of the rights guaranteed under the Access to a Lawyer Directive. Our view is that the proposed directive needs to be strengthened significantly in order to play the role envisaged for it within the interconnected list of measures proposed in the roadmap. In order to facilitate effectively and comprehensively the enjoyment of the rights under the Access to a Lawyer Directive, the scope of the proposed directive must be expanded to cover the provision of legal aid throughout the legal proceedings, in all criminal cases and not just arrest warrant proceedings. In some member states in which final decisions on legal aid are made relatively quickly, the provision of legal aid under the proposed directive will actually be very minimal, and the majority of the criminal proceedings will take place without any EU minimum standards applying. One of the concerns repeatedly raised by members of our network is that suspects who need and should be entitled to legal aid waive their rights of access to a lawyer on learning that there is a possibility that they may sometime later have to pay for such access. The only way to avoid such unwanted waivers, which do not reflect a desire not to have a lawyer, but rather a desire not to be stung for the costs at a later stage, the only way to avoid that is to remove any prospect of costs being recovered for that period of provisional legal aid provision, during which a suspect is arguably at his or her most vulnerable. We'd therefore like to see the removal of any reference to cost recovery in relation to that initial period prior to a full eligibility assessment, during which the benefit of any eligibility doubt should sit with the suspect. In terms of what is missing from the proposed directive, the concerns about remuneration, quality and independence, which have been highlighted in our research and in our conversations with network members, have in no way been addressed by this proposal. Further, if the proposed directive is to be expanded to include legal aid as well as provisional legal aid for all criminal cases, it will need to establish criteria for eligibility using a means and/or a merits assessment. Finally, as with the proposed directive on safeguards for children, there is no provision for remedies where the suspect is not able to enjoy the rights to legal aid granted by the proposed directive. And this will inevitably have implications for the enforceability of the rights established by the proposed directive. In terms of whether there are real prospects of us seeing an expanded scope of the proposed directive, the negotiations on this measure, as was probably to be expected, are proving to be very challenging, both within the EU institutions and between them. So challenging are they proving to be that we've been led to believe that the Council is still a long way off from being able to agree a general approach. The Parliament is making quicker progress, with a draft report published by Dennis de Jong, the GUI MEP and returning member of the Libe Committee, who's in charge of this file. He published his report at the end of 2014, and Mr de Jong has spoken publicly about his intention to expand the scope of the directive in the Parliament's position, bringing in a lot of the standards which were relegated to the Commission's recommendation on legal aid in an attempt to create as robust and enforceable directive as possible. And that certainly seems to be what he's doing, based on the draft report that we've reviewed, albeit, in our view, with scope to push even further in some places. And our hope is that we'll end up with a strong Parliament position which will serve to prevent the Council from going too far in the opposite direction. What's becoming increasingly evident is that we should not be expecting an adopted directive on legal aid in the near future, and that there will no doubt be a period of some time following the transposition deadline of the Access to a Lawyer Directive at the end of 2016, when there are no EU legislated standards on legal aid to aid its effective implementation. Turning finally then to the proposed directive on the presumption of innocence and the right to be present at trial. This measure was not included in the list set out in the roadmap agreed in 2009, but as a central aspect of the right to a fair trial, which clearly contributes to the enjoyment of all other procedural rights, it's referenced as an issue which the Commission should consider in the Stockholm programme under which the roadmap was adopted. Indeed, in the explanatory memorandum which accompanies the proposed directive, the Commission states that in case of persistent breach of presumption of innocence in the Member States, the objectives of the procedural rights agenda could not be fully achieved. We published our position paper on the proposed directive in November 2014. Again, that's available on our website. And in it, we highlighted that while the presumption of innocence lies at the heart of fair trial rights protection and is entrenched in both international and domestic law of all EU member states, the UN Human Rights Committee was right to point out that it's expressed in very ambiguous terms often, and often entails conditions which render it ineffective. The proposed directive is therefore welcomed as an attempt to create specific and enforceable safeguards which aid compliance with this fundamental principle. Our network members have drawn our attention to various examples of how the presumption of innocence is violated in day-to-day practice in member states, with particular concerns raised in relation to witnesses not being advised of the right to silence, but their statements subsequently being used in proceedings after they've become suspects, public pronouncements of guilt, particularly in the context of pre-trial detention hearings, media portrayals of suspects which serve to violate the presumption of innocence, and also the presentation of suspects in court wearing handcuffs, for example, in ways which contravene this central principle. Network members have also expressed concern that certain forms of coercive plea bargaining could be deemed to be an infringement of the presumption of innocence and the right not to incriminate oneself, and that summary proceedings, which are growing increasingly popular in many member states as the drive towards efficiency is prioritised, these summary proceedings do not always respect the imposition of the burden of proof upon the prosecution. There seems to be little doubt then that the establishment of minimum standards in this area would be welcomed by defence practitioners. So what does the proposal cover? The proposed directive is broad in scope, applying to natural but not legal persons throughout criminal proceedings. The measure is divided into two main chapters, the first being the right to presumption of innocence, which includes the prohibition of public references to guilt before conviction, the confirmation that the burden of proof is on the prosecution in all but very limited circumstances, and that the standard of proof should be beyond reasonable doubt. The right not to self-incriminate other than in certain limited circumstances where compulsion is deemed acceptable, and the right to remain silent with no possibility for inferences to be drawn from doing so. The second chapter is the right to be present at one's trial, and this sets out the right to be present, the circumstances in which non-presence may be acceptable, and the right to a retrial where presence was not guaranteed. A third chapter includes a very welcome provision on remedies for suspects whose rights under the directive are breached. In terms of how the proposal could be improved, the comments set out in our position paper, fall into two categories: those which seek to strengthen the existing content of the proposal, and those which suggest additional safeguards which should be added. In terms of strengthening the existing content, our view is that the prohibition on public references to guilt before conviction should be broadened to include, amongst other things, leaks by law enforcement authorities, judicial authorities to the media, and wherever such leaks occur, independent investigations should be conducted. We think that the circumstances in which the reversal of the burden of proof is permitted should be more explicitly and restrictively defined. We'd like to see the obligation to inform suspects of the right to remain silent arise more frequently throughout the criminal proceedings, and that stronger safeguards are included against the unintentional waiver of this right. And finally, we think that the right to be present at one's trial should be enhanced by ensuring that retrials after trials in absentia are not arbitrarily denied on the basis of ineffective information having been provided or onerous deadlines, and should meet the full requirements of Article 6 of the European Convention. In terms of additional safeguards which we think should be added, we'd like to see the inclusion of protections for witnesses as well as suspects to ensure that they fully understand their right not to self-incriminate. We'd like to see the protections for legal as well as natural persons to justify those efforts to ensure that prosecutions of legal persons are undertaken with the same integrity and legal force as those against natural persons. We also think that protections should be expanded to include those administrative proceedings during which evidence may be collected in contravention of the principles upheld by the proposed directive and then subsequently introduced in criminal proceedings. We'd also like to see here the introduction of obligations to audio-visually record questioning as what we consider to be the most effective safeguard against undue compulsion. And finally, we think that the measure could be strengthened by provisions which require member states to ensure that the use of pre-trial detention does not undermine the presumption of innocence. And what are the prospects for us seeing these improvements to the proposals? Well, as was the case in relation to the proposed directive on safeguards for children in criminal proceedings, the Council's general approach doesn't give us much reason to be optimistic. Published in early December 2014, we've got various concerns about its content, including the fact that the door has been opened in the recitals to possible inferences being drawn from the exercise of the right to silence. The proposal gives permission to state authorities to disseminate information about investigations when it would be in the interest of the investigation to do so, which we deduce would often not be in the interests of the defence. The Council's position removes any reference to the standard of proof in criminal proceedings, and it also suggests that statements taken in violation of the right to silence and or the right not to self-incriminate may not automatically be excluded, which we consider to be indication of inadequate remedies. The Council's general approach also includes powers to exclude suspects from trial in broadly defined circumstances. And finally, there's a significant weakening of the retrial protections. Under the rapporteurship of ALDE MEP Natalie Griesbeck, the Parliament has yet to publish its draft report on the proposed directive, but this is eagerly anticipated so that we can get a feel for what the tone of the negotiations on this measure will be. So turning then to some final thoughts on the lessons that we can learn from the implementation of the first three defence rights directives. How do you make sure that the measures that before us end up as robust as possible, but also achieve real improvements on the ground for suspects and defendants across all 28 member states? Alongside our work to inform the development of these new measures, which I've already described, we've also been working with our network members to contribute to the effective implementation of the first three adopted rights directives. And while progress is gradually being made in many member states, there remain widespread examples of how these measures have yet to achieve their full impact. We're reminded that despite having these great laws on paper, the rights which they're intended to protect are still not being enjoyed routinely. And I think there are three key lessons that can be learned, which we hope might inform the approach to the next three directives. Firstly, a lot of the implementation problems we're hearing about arise from the lack of clear guidance and drafting of certain issues in the first two directives, with a lot being left to member state interpretation. Clearly, with 28 member states involved in the drafting, there will inevitably be compromises made. But while these compromises may provide a short-term solution, facilitating agreement on the measure, the Court of Justice of the European Union will inevitably be called upon to provide what will ultimately be a single interpretation of these unclear provisions, which will no doubt leave many member states disappointed. In our position papers, we've highlighted areas where we think the drafting remains insufficiently precise, and we hope that the EU institutions will be mindful of the pitfalls associated with compromise during negotiation. Secondly, there are lessons around enforcement. The absence of remedies provisions in the first two roadmap directives have contributed to implementation challenges. The Access to a Lawyer Directive does go further in an attempt to apply the jurisprudence of the European Court of Human Rights in Sal Dues, but this still remains subject to national rules and systems on the admissibility of evidence. While the proposed directive on the presumption of innocence does include various provisions of remedies, not all of which we think are strong enough as yet, there is no mention of remedies, as I've already said, in the proposals on safeguards for children and legal aid. We hope that these omissions will be addressed during the negotiations as a critical determinant of the effectiveness of implementation. Finally, training of all criminal justice actors is absolutely essential for the effective implementation of the roadmap directives. Yet we've been repeatedly surprised by how little awareness there is of these laws amongst judges, prosecutors, police officers and lawyers. While the first two directives contain provisions which require member states to ensure training for certain actors, there is no such provision in the Access to a Lawyer Directive. And further, none of the adopted directives make any reference to training for defence practitioners who, in our view, have an absolutely central role in ensuring that the rights of suspects and defendants are upheld. We're very pleased to see that there's a provision of training in the proposed Children's Directive, which includes, happily, training of lawyers. But we're disappointed that there's no mention of training in either of the other proposals. We've, as an organisation, have worked very hard to fill the gaps left by the adopted directives by delivering in-person trainings on the first three directives to almost 200 lawyers in the last 2 years, with workshops for a further 200 lawyers scheduled in the next 18 months. In addition, and in the hope of reaching a far broader audience, we've also recently published a series of online training videos, freely accessible via the Fair Trials website, which provide practical guidance for lawyers and others involved in the criminal justice sector on the first two defence rights directives and the role of the CJEU in criminal proceedings. And we do hope you might take the opportunity to look at those. That's all that I have to say today. Thank you very much for taking the time to listen to this presentation, and please don't hesitate to contact me at Libby McVeigh at fairtrials.net should you wish to discuss any of the issues that I've covered today in more detail. Thank you.